Good afternoon. My name is Drew Broaddus. I am a partner at Seacrest Wardle's Grand Rapids office. Thank you for attending today's webinar. Today I'm discussing two emerging issues in first and third-party automobile litigation: TNCs and autonomous vehicles. Does who's at the wheel change who's on the hook? Or in some cases, what's at the wheel, as we'll see. TNCs are transportation network companies. The most notable examples are Uber and Lyft. These are companies that connect paying passengers with drivers who provide transportation in their own non-commercial vehicles. These are currently regulated not at the state level, but under a patchwork of local ordinances. Some communities have tried to ban them. For example, there was a recent crackdown in Ann Arbor that got some attention. At the local level, the issues are whether these drivers need the same business licenses as a taxi cab or a limo would need, and whether they are subject to the insurance requirements of taxis or limos. Specifically, do they need commercial policies? There is a bill that has passed the Michigan House. That's House Bill 4637. It's also referred to as the Uber bill. This passed in June of 2015. And this would comprehensively regulate TNCs once it becomes the law. And I'm told by people that claim to know such things that it will pass eventually in the near future. However, it still has not passed the Senate. The Senate does have a competing bill, but I'm told that that's going to fall away and that HB 4637 will be the one that goes forward. But currently there is no regulation of these at the local level. Now, HB 4637 would be very comprehensive. A TNC driver or a TNC acting on the driver's behalf would have to maintain primary automobile insurance that recognizes the driver uses the vehicle as a TNC driver or otherwise transports passengers for compensation. This is significant because it would do away with the issues we have that we'll discuss down the road about commercial exclusions. It would also require that the policy cover the TNC driver while logged into the TNC's digital network or app while engaged in a prearranged ride. So while logged into the TNC's network and not engaged in a prearranged ride, there would also be insurance requirements. Residual third-party automobile liability insurance, $50,000 per person, $100,000 per accident, $25,000 per property. And they would also need PIP and property coverages in accordance with the No-Fault Act. Other requirements under HB 4637. While logged on to a TNC's digital network and engaged in a prearranged ride, both of the following would be required: residual third-party liability insurance with a minimum combined single limit of $1 million for bodily injury and property damage, and also PIP and property protection in the amounts required by the No-Fault Act. Other enactments that are related to HB 4637 would include changes to the insurance code under HB 4639 and 4640. And these would relate to the relationship between an insurance company and a policyholder who is a TNC or a TNC driver. Also, the motor vehicle code would be amended pursuant to HB 4641, and that would add a new section to the code. It would exclude TNCs and their drivers from the definition of chauffeurs. It would also specify that a personal vehicle operated by a TNC is not a commercial vehicle. And this would outline what types of insurance satisfy the statutory requirements. Apart from legislation, Uber itself offers drivers liability coverage when they are on a trip or logged into the application and available for customers. However, no statute requires this at this point, so Uber could stop doing this at any time. And this doesn't address PIP. This is really just liability coverage so far as we know. Now, Lyft provides similar third-party coverages from the time you accept a ride request until the time the ride is ended in the app. Again, this is not required by statute, so Lyft could likewise stop offering this at any time. It seems to be something they're doing at this point just to build goodwill and avoid controversy. But in the absence of legislation, nothing requires them to keep doing it. So unless and until HB 4637 passes, we would be dealing with ordinary PIP rules. And the main cases in this regard: Thomas versus Tomczyk, a 1985 published Court of Appeals decision, and then Farmers Insurance versus AAA, a 2003 published Court of Appeals decision that interprets Thomas. The gist of these opinions is that we look to the driver's primary function or purpose in operating his vehicle. This determines whether priority lies under MCL 500.3114 Subpart 2, the insurer of the motor vehicle, commercial situations, or 31141, the general priority clause that puts the injured person's own insurer first in line. The PIP priority analysis in these situations could require a case-by-case factual inquiry into how this particular driver was using this particular vehicle. In Thomas versus Tomczyk, 2 college students were injured in an automobile accident. They were passengers in a vehicle driven by a third student who had solicited passengers for $25 each to take them home from college during a holiday break. 2 of these passengers were covered by their own no-fault policies, so a priority dispute emerged between those carriers and the insurer of the vehicle involved in the accident. The Court of Appeals said that this was not a commercial situation governed by 3114 subpart 2. So the insurer that covered the vehicle involved in the accident was not exposed for the PIP claims of the passengers. That decision was interpreted by Farmers versus AAA. In that case, 2 children were injured while passengers in a vehicle operated by their daycare provider as she was transporting them to school. Again, the Court of Appeals held that this was not a commercial situation governed by 31142. The panel noted that the case was factually distinguishable from Thomas to the extent that, unlike the isolated incident of carpooling during which the accident occurred in Thomas, the incident in this case took place as the daycare provider drove the children to school, something she routinely did 3 to 5 times a week. However, the daycare provider's driving of the children to school did not fall within subpart 31142 because, first, her driving of the children to school in her own vehicle occurred incidentally to the vehicle's primary use as a personal vehicle. This is significant for Uber and Lyft drivers who bought their vehicles for other reasons and picked up the TNC driving as a side gig. And in the Farmers versus AAA case, the second reason it wasn't a commercial situation is because the transportation of children to and from school constituted an incidental or small part of the daycare business. So it was not considered the operation of a vehicle in the business of transporting passengers under 31142. And the panel found that this was consistent with the legislative intent that 31142 applied to truly commercial situations, taxis, buses, chauffeurs. Schiller versus Homeowners was my case. This was an unpublished Court of Appeals opinion from 2014. In that case, the insurer of the hotel in Romulus, which provided a courtesy van to and from Metro Airport, was held to have priority under 31142. This was because the primary, if not exclusive, purpose of the courtesy van was to transport passengers to and from the airport. And given the location of the hotel, this was considered a significant part of the hotel's business. What this shows to me is that under 31142, 1, it's not limited to taxi cabs and buses, which the Farmers versus AAA case sort of implied. And the key seems to be whether the transportation is part of a commercial enterprise. For third-party claims, there are business exclusions that we have to be thinking about. And there's a couple cases cited in this slide for the proposition that those exclusions are not superseded by anything in the No-Fault Act or the Motor Vehicle Code. When the insured is the driver, the carrier should also be thinking about rescission if their applications ask relevant questions and the insured does not disclose working for Uber or Lyft. The omission of this could be considered a material misrepresentation. And we know now from the Court of Appeals published case from June of 2016 in Bozzi versus Sentinel that rescission is available even if there are claims by innocent third parties and even if the misrepresentation was, quote, easily ascertainable, end quote, by the insurer. Now, we expect the Bozzi decision to be reviewed by the Michigan Supreme Court sometime in the next year or so, but as it stands now, Bozzi, as a published case of the Court of Appeals, is the law. Rescission is available, and if the application asks relevant questions and they are not answered, and the insured's practice of driving for Uber or Lyft is not disclosed, there may be grounds to void the policy ab initio as if it never existed. Uber has some issues worldwide that are notable when we think about this and how it's regulated. There are entire countries that have banned them outright. Others have regulated them to various degrees. Apparently the state of Nevada does not allow Uber and Lyft at all. Just something to think about. There's more at play here in the regulation than just economic protectionism and making sure that taxi cab drivers and the like are taken care of. There are legitimate concerns from a safety perspective and public policy about non-professional drivers offering these services. Now, what is the connection between the two topics? Apart from both being new and emerging issues, the TNCs are looking into having autonomous vehicles. Uber is driving, or should I say releasing autonomous vehicles in Pittsburgh right now. Some are very concerned about it, as this slide indicates. Lyft is also looking into it and expects most of their rides to be autonomous within 5 years. Now, there's a lot of speculation about when we talk about these, since there are not autonomous vehicles actually on the roadway right now. And in this slide, we just give some examples of autonomous vehicles in science fiction. We have the kit car, which was not only a mode of transportation, but also a great friend to David Hasselhoff's character. And then we have the Terminator examples, which is obviously the worst case scenario, and various things in between. But in Michigan, right now, they are still not street legal. There is new legislation that took effect in 2014, which lays the foundation for that to some extent. MCL 257.663, entitled Operation of an Automated Vehicle Prohibited. And there's also an exception in MCL 257.665 for research and development. This statute also provides definitions. For example, automated mode is defined as the mode of operating an automated vehicle when automated technology is engaged to enable the motor vehicle to operate without any control or monitoring by an operator. MCL 257.2b, parent 3. As part of this legislation, which took effect in March of 2014, manufacturers are given immunity from civil liability for any damages that may arise out of aftermarket attempts to turn their products into self-driving cars. Now, this is not the same as giving immunity to the manufacturers of self-driving cars. What this is saying is that manufacturers of regular cars are not going to have exposure if those cars are later altered to be self-driving. There's no Michigan case law interpreting these statutes yet. Other states that have enacted similar legislation are California, Florida, Nevada, North Dakota, Tennessee, and the District of Columbia. Nevada seems to have taken the lead in terms of trying to get these vehicles legal and regulated on the streets, as opposed to just the proving grounds. And Mr. Johnson's article from the Idaho Law Review talks about the Nevada statute in some detail. Apparently the Nevada statute has been around since 2011. And you can see from the quote here, it's quite detailed. They're actually contemplating getting these vehicles on the roadway in the near future. So they've taken it a few steps farther than the Michigan statute has. The federal government is also very interested in this. There have been statements from Washington to the effect that motor vehicle fatalities could be dramatically reduced if autonomous vehicles become the norm. So they are actually contemplating regulations, even though the machines are not out there yet. But it's still not entirely clear if they're technologically feasible. There was a fatal accident involving a self-driving Tesla in Holland just this fall. It's discussed in this slide. There was also a fatal crash in the United States relatively recently, and a Google self-driving car crashed into a bus, although there were no injuries, my understanding. And a Chinese company was able to hack a Tesla car remotely, which brings up a number of concerns. Once legal, and in the absence of other legislation, we'd have to assume that general first and third party rules apply. For PIP, the injured person would still look to their own household first. MCL 500.31142 would still govern commercial situations. If, for example, a taxi cab, limousine, or bus was autonomous, assuming we have autonomous TNCs, that gray area we exist before would still exist between 31141 and 31142, depending on what the primary purpose of that vehicle is. For third party, owner liability would presumably be unchanged under MCL 257.401. The owner of a motor vehicle is liable for any injury caused by the negligent operation of the motor vehicle, whether the negligence consists of a violation of a statute of this state or the ordinary care standard required by the common law, end quote. And presumably MCL 257.520 would still apply and require the minimum 20, 40, 10 coverages, since that's keyed to the vehicle and not necessarily who or what is driving it. There's some known unknowns when we talk about autonomous vehicles. Does a fully autonomous vehicle have an operator? For tort purposes, this could be a products liability issue if the operator's software. Perhaps the operator is whoever enters the destination, such as on a TomTom or Google Maps, or maybe the owner is always going to be considered the operator. These are things that we don't know the answer to yet, And we also have insurance issues if they're stolen or hacked. Interstate commerce and travel is going to be an issue because at this point, some states have not regulated them at all. Some states have in different ways that may conflict with each other. We can't predict what future statutes or amendments to existing statutes might say about this. There's a lot of different ways, a lot of different legislatures could approach this. We also can't rule out the possibility of some new common law development, perhaps analogous to shrink wrap contracts in software where you agree to certain terms and conditions automatically through using the autonomous vehicle. This concludes our webinar, TNCs and Autonomous Vehicles. Does who's at the wheel change who's on the hook? I look forward to addressing any questions you may have. Thank you. Enjoy the rest of your day.